with me this evening.
Thanks for having me again, Michael.
All right, I want to talk about this witness and something that happened just after the questioning we just saw, and see if you can make sort of hay of it, because I certainly couldn't. Right after that, prosecution began to object to this line of questioning regarding excited delirium. We'll discuss that in a minute. But right after that, they told the judge that they wanted the defense to bring out those questions about excited delirium with this very witness in their own case in chief. They didn't think that they should be able to question her about it during their calling of her as a witness in their case in chief. And I, for the life of me, couldn't understand why the judge said okay, and that she would have to come back next week sometime during the defense's case in chief to come and talk about excited delirium. Do you get a sense of why that was? It seemed to me that the prosecution opened the door and they were just cross-examining her and went into that direction in terms of duty of care and all those things. I tell you, I have no idea why that happened.
I think that was a head scratcher too. I think that it was because the prosecution maybe objected that it was beyond the scope. Oftentimes, you might have a situation where a witness can and will be recalled in the defense's case in chief following the prosecution's case. But in this particular instance, because this condition, excited delirium, is a big part of the defense's theory of the case, it doesn't make sense to me for the prosecution to look like or appear that they're hiding something from the jury or hoping that the jury doesn't see something. I think that you've got to hit things head on when you're in trial. And if you're afraid of evidence, the jury is going to pick up on that. And so to me, it looked like the prosecution, quite frankly, was trying to hide something or didn't want something to be brought out in front of the jury at this particular time. I don't know why, from a strategy standpoint, that they would do that.
Yeah, I mean, what's happening right now, Christa? The jury, next time they hear the words excited delirium, they're going to be doubly listening in because they think, oh, this was something important because the prosecution didn't want them talking about it. And what difference does it make if it comes in during cross-examination or during their case? I swear I didn't understand it.
It also can make it appear like the prosecution is prolonging matters, and you don't want to waste a jury's time, right? And so this is also problematic in that respect as well. Why couldn't you just allow these questions, which probably would have taken, moments in the grand scheme of things, and get it over with, rather than having this witness come back, waste her time, waste the jury's time, waste the court's time? Juries don't like that.
Yeah, and you mentioned wasting the jurors' time. One of the questions I wanted to ask you was, do you think that perhaps the prosecution may be over-trying this case? I mean, basically, we saw the same pattern with all these types of witnesses. They get in a few points, and the defense gets in their points regarding the distractions, the totality of the circumstances, and they really had such a great day yesterday with the top cop, and the day before with the most senior cop in the entire department, all saying how they felt about what George Floyd did. And I'm wondering if they need to sort of step back a little bit and move on with their case.
I think you're right. This morning, I was texting friends that are also watching this trial closely about what a bad day I thought that the prosecution was having this morning. The defense, Mr. Nelson, scored a lot of points on cross-examination of a number of witnesses today. And it's not a good look when all of a sudden you're getting these big concessions from what is supposed to be favorable for the prosecution witnesses. So you're getting these training officers to come in to what prior officers have already testified to. You've already got the foundation laid for your use of force expert. I don't know why they had so many witnesses come in to, verify a signature card that a particular class was taken by Mr. Chauvin. I don't know that that was necessary, and I do agree with you. I think that this day was a big fat waste of time for a big chunk of it for the prosecution, and they ended up losing in points.
Yeah, I mean, and juries don't forget that. Like you said, I mean, I think they take it to heart. If you're moving your case along and being efficient in your case, I think they respect that. I think if you're taking too long, it becomes a problem. I will say this, though. I do understand that in terms of proving intent, they need to show that Derek Chauvin took all these classes when they're telling this jury he didn't do these things, and that's why we want you to infer intent. You kind of have to show that he did, in fact, take these classes and was taught better.
Yeah, so you think that they could have handled that, though, with a custodian that could take these items out of Mr. Chauvin's personnel file and verify that all these courses were taken? And this is, in fact, Derek Chauvin's signature, and this was, in fact, part of his employment file. I think that it could have been done more effectively and more efficiently.
Fair enough, without giving the defense the opportunity, as we said, to score all the points that they've been scoring with those witnesses. All right, stand by, Christa. We're going to take a break right now, but when we come back, George Floyd's friend Maurice Hall is trying to plead the Fifth Amendment, so he will not have to testify.